Welcome to the Supreme Court of the United Kingdom, where today we are hearing an appeal in the case of Burnett and the International Insurance Company of Hanover Limited. I'm hearing this appeal with four of my colleagues, whom I'll introduce now. First, Lord Briggs.
Good morning.
Lord Hamblin.
Good morning.
Lord Leggett.
Morning.
And Lord
Good morning.
Ms. Burnett, who has brought this case, is the widow of a Mr. Grant, who died in 2013 following an assault by a door steward at a bar in Aberdeen. The employers of the door steward had an insurance policy with the defenders, International Insurance Company of Hanover Limited. And the issue in this appeal, put very briefly, is whether the insurers are liable under the insurance policy to indemnify the employers in respect of the death. The appellants, who are the insurance company, are represented by Mr. McBrearty, QC, and Mr. Appellant. And I'll invite Mr. McBrearty now to make his submission. Mr. McBrearty.
Good morning, my lords. Thank you, my lord. I, of course, appear with Mr. Cleland, Mr. Milligan, Mr. Weir, and Mr. Hasty for the respondents. And before I embark on my submissions, my lords, might I just apologise to the court. I understand that there was a difficulty with parts of the electronic appendix which were provided to your lordships last week, and I understand very well how irritating it can be to open electronic papers only to find that they're not legible. The responsibility for that lies with me, and I do apologise to the court for that.
Well, we now have a bundle which is in proper form, so that's fine. Thank you.
At the outset of the appeal, might I also say this, my lords? Anyone coming to this case, in whatever capacity they come to it, is bound to be struck by the terrible human tragedy that lies behind it. And I simply wish to acknowledge that, as it seems right to do so before I embark upon dealing in the minutiae of the insurance policy with which we're concerned. But of course, that is what the appeal is concerned with. And in my respectful submission, the First Division of the Inner House erred in their interpretation of the policy. If I may take your lordships directly to the key provisions of the policy, and my intention is to take them to the provisions first, to consider those provisions and the overall context of the policy before considering a number of the authorities, and then turning back to consider the facts of the present case, all subject, of course, to the order in which your lordships may wish me to deal with matters. The first provision I might ask your lordships to look at is the insuring clause itself. It's to be found at MS 142. MS 142. And one sees there an insuring clause which, in my submission, is essentially unremarkable in its terms. The appellant indemnifies against all sums that the insured shall become liable to pay as compensatory damages together with costs and expenses. And I note, of course, that it is in respect of three areas of cover. It is in respect of injury to any person under subhead A, B, physical loss of or physical damage to material property, and C, obstruction, trespass, nuisance, and so on. And of course, accidental, the word accidental qualifies each of the types of cover. And let me make clear at the outset, my lords, what I accept the insuring clause would cover, were it not for the exclusion and extension clauses, which I'm also going to come on to direct your lordships to. The legal liability in respect of which cover is provided is, of course, the liability of the insured, in this case, the employer of the door steward who committed the assault in question. And I accept that the insuring clause, if looked at alone, is apt to provide indemnity in respect of the insured's vicarious liability for the acts of its employee door staff, including deliberate acts of door staff. And I acknowledge this, my lords, it is, of course, a basic rule of insurance law. It's been referred to by both parties in their printed cases, that a contract of insurance does not cover an insured against the deliberate infliction of loss, at least absent express wording to the contrary. And that's a well-known basic rule. It's perhaps best known statement of that rule is the statement by Lord Atkin in the case of Beresford against Royal Insurance Company Limited. I don't think I need ask your lordships to turn it up, but should they wish to see the way in which it's expressed by Lord Atkin, they will find it at tab 13, particularly page 595 of the report, and that's at MS 526. MS 526. But I accept that that basic rule of insurance does not prevent an insured in principle from taking out insurance which would cover the deliberate acts of his or her employees, or indeed even the illegal acts of his or her employees. And consistent with that, my lords, when one is looking at this particular insuring clause, I would accept that the question of whether any injury is accidental is to be tested from the perspective of the insured. And that is, of course, your lordships will have seen the case of Hawley, the Court of Appeal decision in Hawley against Luminar Leisure, which to some extent is analogous to the present case, certainly similar on the facts. And that was the key to the Court of Appeal's decision in that case, that the question of whether it was accidental was to be tested from the perspective of the employer as the insured. And so, adopting the same approach to this insuring clause, my lords, I accept that this insuring clause would be apt to provide indemnity for liability which the employer would face as a result of the incident with which we are concerned here. But of course, matters do not rest at the insuring clause alone. And if I might ask your lordships to move 2 pages on from the insuring clause to look to the exemption clause with which we're concerned, clause 14. That's at MS 144. And before I ask your lordships to look at some of the detail of the clause, if I may just emphasise the 2 key aspects of the argument which I make regarding this clause. The first is that deliberate act, where it's used in clause 14, in my submission means an act intended to cause injury. The effect of clause 14 is to exclude an indemnity which would otherwise arise under the insuring clause in respect of accidental injury. And so an intention to cause injury amounts to a deliberate act. The short point being the actor need not intend the specific injury which ensues from the deliberate act. It is enough that the actor intends injury. The second main point that I make about this clause is that in my submission, my lords, deliberate should also be interpreted as encompassing reckless acts. Now, having highlighted those 2 main strands of the argument that I make about this clause, my lords, if I might ask your lordships to look at the very first part of clause 14, in particular the words up to neglect. So the words liability arising out of deliberate acts, willful default or neglect. And pausing at neglect there, if I may make 4 brief points about that first part of the clause, up to neglect. The first is the obvious point, of course, that the exclusion is in respect of liability. In other words, the legal liability which would otherwise be indemnified in terms of the insuring clause. So the exclusion is for liability. The second point I make is that it is plainly intended that there should be an exclusion of a liability arising out of both relevant acts and omissions. And we see that from the use of the words, on the one hand, deliberate acts, and on the other hand, willful default or neglect. There's a clear distinction between acts and omissions. Thirdly, in my submission, if one looks to the adjectives which qualify on the one hand the acts and on the other hand on the omissions, in other words, deliberate on the one hand and willful on the other, in my submission, they should be regarded as synonymous. Deliberate and willful should be taken effectively as meaning the same thing in the context of this clause. In my submission, in their ordinary use, both carry the natural meaning of the act or omission being intentional or consciously done. And it may simply be, my lords, that the use of the two adjectives may simply reflect that in normal usage, deliberate is perhaps the more natural adjective to be used to describe a positive act, whereas willful may be the adjective which might be used more naturally to describe a conscious decision not to act. But in my submission, there is no difference in substance between them. The fourth point I make is, of course, that the words which are used just at the beginning of that phrase are arising out of. The exclusion covers liability arising out of the deliberate act or willful default or neglect. And thus, by those words, there must be a causative link between the relevant act or omission and the liability which ensues. And I observe at this point, my lords, that in this appeal, the parties differ as to what meaning is to be given to the words arising out of. But in my submission, it really doesn't matter on the facts of this particular case. As your lordships will have seen from the printed case, the respondent contends that arising out of should be given the meaning of proximately caused, whereas the appellant contemplates a more remote causal connection than that. But on the facts of this case, that difference is not one in my submission which matters, because it is not in dispute that the death of the deceased was caused by the chokehold placed upon him by the door steward. So if the proximate cause is what is required, then in my submission, that test is met. I'll return in a moment to the key question of deliberate acts and the meaning of that, but before I do that, if I might ask your lordships then to contemplate the second part of the clause after the words which I've looked at. I paused at neglect, and following on from there, we see that the actor or default is by the insured, any director, partner or employee of the insured, other than set out in extension 1 and so on. And for the avoidance of doubt, extension 1 and extension 2 are of no effect here. And if I might just emphasise about that latter part of the phrase, the importance of those words in my submission is that they make clear that the liability which is excluded arises not just out of the deliberate acts of the insured, but also the acts of these classes of individuals for whom the insured would otherwise be liable. And the result of that in my submission is that where the act in question has been carried out by an individual in one of those classes, whether it is deliberate or not, should be tested from the perspective of that individual, rather than from the perspective of the insured. So in short, the adjective deliberate and equally the adjective willful speaks to the state of mind of the relevant actor, in this case, the employee. And standing back just for a moment from the detail of the words used, one might ask, what is the overall purpose of the exemption provided for by clause 14? And in my submission, in effect, what it does is to introduce into the policy the same basic rule of insurance, which I've already referred to, but in relation to the acts and omissions for those for whom the insured is liable, as well as in relation to the acts and omissions of the insured themselves. So in other words, the insurer will not indemnify where one of these classes of individuals deliberately brings about loss of the type which would give rise to the indemnity under the insuring clause. Which brings me back, my lords, to the words deliberate acts, which are key between the parties in terms of this appeal, and how the words deliberate acts are to be interpreted. And if I might just remind your lordships of the competing interpretations as I understand them. The respondent's interpretation is that the act must mean the causing of the injury. The causing of the injury, by which the respondent means the specific injury which in fact ensues. Thus, on the facts of this appeal, for the doorman to have carried out a deliberate act, he would have had to have intended to cause the death, which gives rise to the liability. On the respondent's argument, it would not be sufficient that he intended to assault and thereby cause a more minor injury, and that the death was an unintended consequence. The appellant, by contrast, argues that deliberate act means simply that the relevant actor intended to cause injury. And in my submission, my lords, the appellant's interpretation is consistent with the words used in the policy and the overall purpose of the clause looked at as a whole. I remind your lordships, of course, that what is covered and indemnified in terms of the insuring clause is accidental injury. The indemnity provided is for liability for compensatory damages arising out of accidental injury. And what is being excluded under clause 14 is liability arising in effect out of accidental injury. So in my submission, tying in the words together in the insuring clause and clause 14, for an act to be deliberate under clause 14, it is sufficient that it is an act intended to cause injury. In other words, an injury of the type which is otherwise indemnified, because what we have is an exemption from that indemnity. And in my submission, once it is established that the relevant actor intended to cause injury, the question of whether clause 14 then takes effect in respect of the liability for the specific consequences of that act is then determined as a matter of causation, because one then turns to look at the words arising out of, where they appear towards the beginning of clause 14. In other words, was the liability one arising out of the deliberate act, that being an act intended to cause injury? And in my submission, my lords, I simply observed that the same interpretation would apply equally in respect of the other types of cover provided for under the insuring clause, because of course, as I drew your lordship's attention to, the insuring clause does not simply provide cover in respect of injury, it also provides cover in respect of property damage and in respect of obstruction, trespass, nuisance, and so on. And so if an insured's employee commits a deliberate act, if it is, for example, intended to cause loss of or damage to property, then that would be a deliberate act for the purposes of clause 14, irrespective of whether the consequences of that act turn out to be exactly and precisely what the relevant actor intended. So in my submission, my lords, clause 14 in the words of it tie back to the insuring clause. To read it in the way in which the appellants submit, it makes sense of the exemption clause and the purpose which it provides for in terms of the policy. I further submit this, my lords, is that the appellant's interpretation in my submission also prevents, in my submission, absurdities which would otherwise arise on the respondent's interpretation. And if I may just highlight what in my submission would be some of the potential absurdities which would arise on the respondent's submission, and seek to explain, having looked at some of those, then seek to explain the underlying reason why those ought not to arise. And if I may take the factual circumstances of the Court of Appeal case of Hawley as a starting point, suitable starting point to consider some of those absurdities. Your lordships will recall, of course, that's a case in which, like the present case, an assault was carried out by a doorman on a customer, except the circumstances of that case were that the doorman punched the customer in the face, and regrettably the customer stumbled backwards, hit his head off the pavement and suffered brain damage. If one is to take that as a starting point, as an example, if a door steward deliberately punches a customer in the face with the stated intention of breaking his nose, for example, if he then succeeds in breaking the customer's nose and no more, then on the respondent's interpretation, clause 14 takes effect and there is no cover, because the act, on the respondent's view, must mean the causing of the injury, the intended injury. And if the doorman intended the broken nose, and that is the result of it, so on the respondent's interpretation, it was a deliberate act. But if, as occurred in Hawley, the customer has his nose broken and also falls backwards, hits his head and suffers brain damage, then on that view, clause takes no effect, clause 14 takes no effect, and there is cover, because the doorman did not intend to inflict brain damage, despite the fact that he did intend to inflict injury, and despite the fact that the brain damage plainly arises out of that deliberate infliction of injury. In my submission, that would be an absurdity if there was a distinction between those two situations. One might also posit the situation of what if it were the other way around. Let's imagine that the doorman takes a hammer and attacks a customer with the stated intention of killing him, stated intention of hitting him on the head and killing him. But just before he's able to land the fatal blow, his colleagues manage to pull him back, and he only succeeds in breaking the customer's nose. On the respondent's interpretation, there would have been no cover if he had succeeded in killing him, but there is cover for the broken nose, as he didn't intend to cause that injury. And without wishing to go on too long with these examples, my lords, I mean, one can equally come up with examples in respect of the other types of cover which are the subject of the policy. For example, in relation to property damage, if a door steward in a fit of rage were to take a sledgehammer to a customer's car with the intention of damaging it, he will have intended to cause that physical damage, that damage to property, and in terms of the insuring clause. So that on the respondent's view, clause 14 would take effect and there would be no cover for the damage to that car. What if he hits the car so hard that it causes the handbrake to be released and the car rolls down a hill, causing damage to another customer's vehicle? Plainly, he didn't intend to bring about that specific consequence. He did intend to cause the initial damage to the property, which is the subject of the indemnity. And on that view, that potentially, on the respondent's view, might be covered. And in my submission, my lords, looking at those practical questions and some of the absurdities demonstrates that the appellant's interpretation is to be preferred. And I observe this about the argument made for the respondent, which is this, that the respondent suggests that her interpretation should be favoured because it is more consistent with what would be expected of insurance of this type. In other words, it is suggested that one would expect an insurance company to cover the acts of door staff in circumstances where they are known to be in contact with the public and it is known that they may require to provide some kind of, use some degree of physical force. I simply observe this, that the respondent's interpretation doesn't create any greater uncertainty for anyone, because on the respondent's interpretation, what we have is some consequences of deliberate acts will be indemnified, some will not, effectively depending upon the chance consequences of the act. For example, whether or not somebody trips after having been deliberately struck. And that's the key in my submission of the respondent's position, is that they seek to have the question determined upon whether or not chance consequences of an act are covered or not. And that really leads me into making my submission as to what the underlying reason is why these absurdities ought not to arise. And in my submission, the reason for that is because insurance is essentially about providing cover for uncertainties. It ties in, I suppose, to the basic rule of insurance, which I've already discussed. Insurers do not cover liability caused by acts brought about by an insured, because those events are not uncertain. They are brought about by the insured themselves. And in a sense, it would violate the whole concept of insurance. And interpreting clause 14 in my submission, the insurer should not be understood to be providing cover in relation to the chance consequences of a deliberately harmful act. The consequences are uncertain only to the extent that all sorts of things can happen once an insured or a person for whom they are responsible deliberately inflicts injury or damage. The consequences may be exactly what were intended. The consequences may be worse than were intended. The consequences may transpire to be not as bad as were intended. But those are all simply consequences following upon a deliberate infliction of injury or damage. And on the respondent's argument, the insurer would have to effectively be held to be saying that once an act is carried out with the intention of causing injury or property damage, they are providing cover in respect of the uncertain results of that act. And in my submission, that's simply not the kind of uncertainty that insurers should be understood to be insuring against. On my example, again, coming back to the facts of Hawley, in a scenario where it is effectively said, if A punches B, or to make it more florid, if I were to punch Mr. Milligan, wholly unlikely, I accept, but if I were to punch Mr. Milligan, what do we think will happen? Will I fail to do any damage or cause any injury to him? Will I break his nose as I intend, or will we be much more unlucky than that and a more serious injury or consequence will ensue from that? And in my submission, when one puts it in that way, what one comes to is that that sounds rather like a bet, but far more like a bet than insurance. And in my submission, the insurer should not be taken in terms of clause 14 to be covering that kind of uncertainty. And in real terms, my lords, what it comes to in my submission in terms of clause 14, and of course I haven't yet come to extension 3, which in my submission is a very important extension, but in real terms in clause 14, looking at the interaction between the insurance clause and clause 14, what is covered is negligence and the consequences of it. And what is excluded are intentional delicts or torts and the consequence of them. Now, at that point, my lord, if I might just mention the secondary argument which I made reference to when I first addressed your lordships in clause 14, in my submission, in any event, deliberate should be construed to include reckless acts. Now, I'll come to develop this, if I may, when I look to some of the authorities, which I'm going to draw your lordship's attention to. But the essential point in that respect is this, my lords, that on a proper construction of the exemption clause, if the insured or those for whom the insured is responsible has acted knowing that their act risked injury, or without caring whether it was risky or not, then in my submission, that is not a risk that one would have expected the insurer to accept. And that in my submission should be reflected in the interpretation of deliberate, which should be taken as incorporating recklessness. My Lord Legate, I think, is a question.
I just wanted to take you up, if I may, on your proposition that the line is between intentional torts and negligence.
Yes.
Because, as I understand it, you're not, in fact, maintaining that an assault would be excluded if as a tort or battery if there was no intention to cause injury. I mean, an assault is any unlawful, unwanted touching, isn't it, of another person? But you're, as I understand it, drawing the line where somebody in what in English criminal law would be an assault causing actual bodily harm, or at least that's been intention to cause some actual bodily harm.
It's an intention to cause injury, my lord, that I draw because of the drawing the connection between the insuring clause and the clause 14. Yes. Although, of course, as I'm coming on to argue, my lord, that the very specific context of this policy means that by the use of express words, the insurers have been taken to cover certain deliberate acts in terms of extension 3, and I'll come on to address that. And it may be that I can assist further once I've addressed your lordship on that particular clause.
Yes, can I just press you on that point so I understand it? Again, you were drawing the distinction between intentional tort and negligence. My understanding, and I don't think there's any difference here between Scottish and English law, is that the torts that we're here concerned with, that is assault and, if one differentiates it, battery, are intentional torts, but the intention is in relation to the application of force. It is not the intention to cause injury. And I just wondered what you'd say about that submission.
My lord, I think in the context of an intentional delict, if I may, it respectfully seems to me that certainly in this context, the intention would have to be to cause injury, or at least, and then one would have after that the application of the causation in order to determine whether the actual effects of that flowed from the delict. But it respectfully seems to me that in a delictual context, one would be looking to an intention to cause injury.
Well, what about, for example, if the door steward were to indecently assault a female customer? Yeah, he fondles her breast, for example. That's an assault.
Yes.
Functional delict, but it doesn't involve any intention to injure.
No, I take your lordship's point. It respectfully seems to me, well, query what the interpretation would be of injury in that case in the context of the clause, whether or not that would be interpreted sufficiently widely to encompass that. In other words, that would be encompassed for the purpose of this act as being an injury.
I don't think I follow your answer. It's simply a counterexample to the proposition that clause 14 differentiates between intentional torts or delicts on the one hand and negligence on the other.
Yes.
I mean, equally, if the doorman were to produce a posh, for example, in order to persuade a customer to leave, or say he pulls out a knife and points the knife at the customer to encourage them to leave, that would be an assault, although it doesn't involve an intent to injure.
Yes, I take your lordship's point. Well, it may be that the delineation that I've drawn between intentional delict and negligence is one that up until that point, or that it may not go as far as that, except that may simply be an analogy which I've drawn, which is taking it too far. I take the point that your lordship makes. Is there anything else I can assist with, my lords, in that respect before I move on to the extension 3, my lords, is of course the extension which is named wrongful arrest, and that is first of all mentioned in the context of being an exclusion to the policy in terms of clause 20. That's at MS 144 to 145. But that is then included by way of an extension at MS 148. And if I might ask your lordships to look briefly at that. Extension 3 then provides, headed wrongful arrest, the insurers will indemnify the insured in respect of all sums which the insured shall become legally liable to pay as compensatory damages arising from or out of wrongful arrest. Committed or alleged to have been committed by the insured, and again, any director, partner, or employee. And again, as with clause 14, it covers those for whom the insurer is liable. And your lordships will find the definition of wrongful arrest at MS 141. And the definition, headed wrongful arrest, means any unlawful physical restraint by one person on the liberty of another, and thereafter includes the two specific points, which are below numbered as 1 and 2. And in my submission, if one just looks to the opening line before one comes to those 2 points, the definition is any unlawful physical restraint by one person on the liberty of another. And reading extension 3 together with that definition, in my submission, what is being provided is an indemnity in respect of legal liability arising out of unlawful physical restraint by one person on the liberty of another. But in my submission, on the words used there, the legal liability need not be in respect of damages for deprivation of liberty. On that wording in my submission, it may just as well be for the unlawful physical restraint per se. And as your lordship will appreciate, for the insurers, in effect, I am submitting for a broader interpretation rather than a narrower interpretation of that clause. And I submit then that it is not simply indemnifying in respect of deprivation of liberty, but for the unlawful physical restraint in and of itself. And in my submission, the point is accentuated when one looks on to then the words "and includes," because what we have then are 2 specific numbered points which are expressly included within the definition within their own right. And the first of those is particularly apt to the present circumstances. And if I might just ask your lordships to, sorry, my Lord Legate.
you don't need this extension where there's injury, though, do you? I mean, one can accept that it includes assault and battery, going back to what we just talked about.
Yes.
But in Lord Reed's example, you can have an assault without any injury, and equally you could have a battery without an injury. So the extension is to take in those kind of incidents, isn't it, in the context of physical restraint? If you've got an injury, then you're under the cover anyway, potentially subject to the exclusion, but without having to invoke the extension.
Yeah. Yes, my lord.
So what I'm saying is you can't rely on the extension, in effect, to cut down cover for an injury.
My lord, let me make clear that the insurer's position is that the extension extends cover and is not used to cut down the cover. If anything, in the context of this particular policy, it takes account of the fact that, and if I may just jump ahead a little bit, it is an agreed aspect of the background here between the parties that it is known, of course, that door staff, by the very nature of their job, are required to engage in physical confrontation at times with customers. They may perfectly well require to do so legitimately in order to protect other customers, to prevent people entering, to prevent violence and so on. And therefore, it is a recognised part of a door steward's job that they may require to engage in physical contact with customers. They equally then, it is, I think, recognised by both parties, and for my part, I recognise that there may be circumstances in which there may be a fine line between what is reasonable force and unreasonable force, what is lawful and unlawful. And that may arise in circumstances where no doubt a door steward is engaging in difficult and stressful circumstances where they have to take very quick calls between what is legitimate and what is unreasonable force. And equally, I think it's recognised by both parties that there may be circumstances in which, unfortunately, there may be some door stewards who simply commit assaults from time to time. That is a fact of life. It may happen, and I think that everyone recognises that. And therefore, one sees the extension here as providing, in effect, by express words, circumstances in which it is put beyond doubt, the insurers are prepared to provide cover. They're prepared to provide cover where there is unlawful physical restraint. They're prepared to provide cover where within that there is assault and battery committed in the specific circumstances which are set out. They are prepared to provide cover where there is libel or slander, false imprisonment, or so on under head 2. And the liability could arise out of any of those matters. In my submission, in the overall scheme of the policy, it's a significant extension because, in effect, what it recognises is that these are the circumstances in which one would expect a door steward to have, it would form in effect part of the normal course of their employment, to have some kind of contact in the context of assault, of restraint, or an attempt to arrest. And therefore the insurer is saying, yes, provided that it arises in that context, in the context of restraint or in the context of an attempt to arrest or so on, then yes, we will provide cover. We will provide cover for that because we recognise that that is a recognisable part of the door steward's jobs. But nevertheless, we will provide cover up to a particular limitation. And as your lordships will see, the limitation is £100,000, and that no doubt is taking account of the risk and the premium and so on and so forth. But yes, there is cover. By contrast, in the circumstances, what is not covered would be an outright deliberate assault. If a doorman were simply, there was an unprovoked attack by a door steward on a customer, then there would be no cover in terms of this. So I don't seek to rely upon this to exclude the cover. On the contrary, let me make clear that my submission is that on the facts of this case, exemption clause 14 applies, extension clause 3 also applies. The general exclusion is in effect trumped by the specific extension, and therefore, given that the facts of this case fall within the extension 3, in my submission, there is indemnity on the facts of this case, but up to the limitation of £100,000. That was perhaps an
Can I just ask, in relation to that point, Mr. McBearty, you're effectively saying that the exclusion is subject to the extension.
I didn't catch that, my lord. Apologies.
As I understand it, you're saying that exclusion 14 is subject to extension 3.
Yes. Yes.
If you look at page 147, under the heading, you'll see the third line. It tells us that all the extensions are subject to all other terms, conditions, and exclusions of the policy.
Your Lordship, on MS 147.
Yes.
And with apologies, could you?
At the top of the page, you've got into Hanover, and then you've got public heading, public and products liability insurance section extensions, and then you've got 3 lines. The third line of text there seems to indicate that the extensions are subject to the exclusion rather than vice versa.
And vice versa. Yes, I take your Lordship's point on that. Does appear to be expressly stated in that way, my lord.
Yeah.
Your Lordship will take the point that I make, which is that, in a sense, it would be, other than that wording, one would read it in that way to provide the specific extension in the specific circumstances. But in those circumstances, then that would militate against that, and that would those words alone would militate in favour of the conclusion that clause 14 would take effect and thereby exclude entirely the loss. If I might turn your Lordship's attention back to the definition of wrongful arrest, I don't think I need labour it much because your Lordships will have had the opportunity to see it in terms, but the point I make is that in the first wording of it, unlawful physical restraint by one person on the liberty of another does not in and of itself contemplate only deprivation of liberty. And that is, in a sense, accentuated by point 1, which is the inclusion of assault and battery committed in the specific circumstances. And one can see that those circumstances are assault and battery committed at the time of making or attempting to make an arrest, or in preventing, resisting an overt attempt to escape arrest. The key part being at the end, before such person has been or could be placed in the custody of the police. So one is contemplating the involvement of the door staff prior to the involvement of the police. And in my submission, on reading the ordinary words used in extension 3, the definition of wrongful arrest expressly includes all of those different events. The legal liability, which, in respect of which indemnity is provided, could arise from or out of any of those elements. They are not, in my submission, to be read as incidental grounds which might find legal liability, but only if they're subsidiary to primary liability for deprivation of liberty. I mean, in a sense, otherwise it would be an odd indemnity to provide by way of extension 3, because a customer of a nightclub might technically be deprived of their liberty unlawfully by door staff, but it would be surprising if it were to be for an extended period, giving rise to any kind of substantial liability in damages. It would seem very much more likely that if a customer has a claim, the value of it will be likely to lie in the consequences of any assault carried out while he or she is being restrained. And yet, on the approach of the respondent in the first division, there would be no indemnity in respect of the assault if the customer sued only for the assault, but there would be an indemnity if he were to sue for deprivation of liberty and were to add in the assault. Now, and for the avoidance of doubt, my lords, your lordships will find, of course, the limitation to the £100,000 in the schedule. I needn't ask your lordships to turn it up, but that's to be found at MS 126. And your lordships will also find, for what it's worth, the details that were provided to the insurers in order to inform the risk that was being granted in terms of the number of employees and so on is to be found at MS 129. Your Lordship will see that in return for the premium was £2,875, and your Lordships will see that what was being provided was cover in respect of, in effect, 10 static or mobile guards and 57 door supervisors. That's at MS 129. Now, unless I can assist your Lordships with any aspects of the policy, I intend to turn to a number of the authorities. And if I might start by dealing with just a couple of the authorities which bear upon the Clause 14 exemption, and shading particularly into those which deal with the question of recklessness. And I might then just touch briefly upon directing your Lordships to those which bear upon the meaning of the term arising out of. The first case I might mention, my Lords, is the case of Hawley against Luminar Leisure Limited. It's at tab 8. I only, I think, require your Lordships to turn up a couple of aspects to it.
I should say, Mr. McBrearty, that we're working solely off electronic copies, so it's helpful if you give us the electronic. We need to have electronic page number.
I will, my Lord. When I come to the particular pages, I'll direct your Lordships to the electronic page numbers. It is, of course, the case I've referred to already, in which the claimant was punched by a door steward, causing him to fall backwards, hit his head and suffer brain damage. And as in this case, the doorman's employer was insolvent, and the claimant sought to make out a case directly against the insurer in similar manner to here. And in a sense, it's impossible not to touch upon this case, partly because of the similarities in the facts to the present case. But in my submission, the principal difference between Hawley and this case is that in Hawley, while the insuring clause was in similar terms to this policy, and there was an extension in almost identical terms to extension 3, the policy did not contain an exclusion equivalent to clause 14. And the result was that before the Court of Appeal, the case turned not on whether the act of the door steward was a deliberate act, but on whether the injury inflicted was accidental bodily injury in terms of the insuring clause. And the key point in that respect, and your Lordships will find this at particularly paragraphs 106 to 109 of the Court of Appeal's judgment, that's at MS 377 to 378. The key point that is made by the Court of Appeal there is that whether the injury was considered to be accidental should be viewed from the perspective of the insured, not the door steward employee. And that is because it was in terms of the insuring clause, and the party mentioned was the insured. And moreover, there was no basis to attribute the state of mind of the door steward to the employer for the purposes of the insuring clause. And one sees that particularly at 106 and 109 to 109. At 106, in the second part of the paragraph, one sees, your Lordships will see the Court of Appeal referring to the basic rule of insurance, to which I've referred already. And at 107, reading from the third line in on 107, if your Lordships have at the very end of, very right-hand side of the third line in, the question which therefore arises is whether, for the purposes of the policy in the present case, and in particular paragraph B2, that was, for the avoidance of doubt, that was the insuring clause, my Lord, as expanded on by the definition in paragraph A1, one should attribute the state of mind of Mr. Warren, who was the door steward, to ASE, as is argued on behalf of the underwriters, or whether, as the judge held, ASE and Mr. Warren are to be treated as separate from the perspective of the policy, so that the intention of Mr. Warren in causing the bodily injury should not be attributed. And at 108, then the Court of Appeal then says that there are a number of points which, when taken together, persuade us that the judge was correct in his conclusion. First, the policy recorded the type of business in respect of which ASE were being insured as security guards, including door supervisors. Thus, the policy was concerned with protecting ASE against liability arising from the actions or inactions of their security guards and door supervisors. In those circumstances, one of the most fundamental concepts underlying the policy was that the insured would be covered for damages which it had to pay owing to its vicarious liability for its employees' torts. Thus, it can be said with real force that one would not expect the underwriters to be able to invoke ASE's vicarious liability for its doormen as a ground for avoiding, as opposed to accepting, liability under the policy. Now, I pause just to reflect on that passage of what the Court of Appeal says, my lords, because it's a point, of course, relied upon by the respondent here to say one would expect the actions of the door staff to be covered of a policy of this sort. And I simply observe that, again, on the basis of the policy that was before the Court of Appeal, they did not have before them a clause in the terms of clause 14. They were only looking at it from the perspective of the insuring clause, without a specific exclusion clause having been introduced in the terms in which it was provided for here. And that, in my submission, is a significant difference between that case and the present case. And one then sees the conclusion of this aspect of the reasoning, reading from the third line in on paragraph 109, where it stated, in this case, the bodily injury inflicted on the claimant was accidental or indeed fortuitous from the perception of ASE, in the sense of its board of directors, as Mr. Stuart Smith realistically accepts. On that basis, it would only be if one could attribute the state of mind of Mr. Warren to ASE that one could conclude that the bodily harm inflicted in the present case was not accidental or fortuitous from ASE's perspective. But why should one do that? It is not even as if the principle of vicarious liability involves attributing the state of mind of the employee to that of the employer. It is merely concerned with extending legal liability from employee to employer. And one sees then that, in my submission, is the key to the decision. One sees at paragraph 109, because again, one is looking at accidental in Hawley from the perspective of the insured in terms of the insuring clause, whereas in the present case, one is looking at it in terms of clause 14, expressly in terms of the state of mind of the relevant actor, in this case, the employee who is actor specifically covered. So for that reason, in my submission, there is really no direct assistance to be gained from Hawley. I mention it simply because it is so similar on the facts that it is impossible not to mention it, but in my submission, it's a different emphasis which appears from that case compared with the present one. If I might also mention, my lords, the case of Gray and Barr, and it is, of course, a well-known case. Your lordships will recall it's memorable on its facts. It is a case which is concerned with the 2 shots fired from the shotgun, the first of which was deliberately fired, the second of which was accidental but fatal, and the result of which, from the perspective of the insurance policy, was that the ensuing death was not accidental because it was not caused by the second shot, but by the decision of the defender to take the gun loaded upstairs and to fire the first shot. Now, I only wish to refer your lordships to one excerpt from the judgment of Lord Justice Salmon, as he was, but if I might explain why, in my submission in context, this isn't a valuable excerpt. And let me say this is a case which at first glance on its facts is quite different to the facts of the present case. Of course, it relates to a differently worded clause, but in my submission, there are quite close parallels. In Gray, the differences are, of course, that in Gray, the Court of Appeal was concerned with the interpretation of the insuring clause. It was concerned with whether the death had been caused by accident. And on the facts of that case, the court was faced with 2 competing causes. Was it the second accidental shot, or was it the decision to go upstairs with a loaded gun and then fire it? And by contrast here, of course, we're not dealing with an insuring clause, we're dealing with the exemption clause. So we're considering the interpretation of deliberate acts. And on the facts, we don't have 2 competing causes. There is only one cause, the neck hold applied by the bouncer, in effect, by the case. And the question is, what is required to render that single act deliberate? Is it the intention to cause injury, or must it be the intention to cause the consequences which ensue from that? But those are the differences. But in my submission, the case is, in a sense, might be viewed as two sides of the same coin because of the close connection between, on the one hand, accidental and on the other hand, deliberate. It is not surprising that some of the obiter dicta of the Court of Appeal in Gray, one finds observations that may be relevant to the present case, because although we have differences in terms of the facts and the clause, there is some degree of similarity about the case. And in that respect, if I may just draw your Lordship's attention to the dictum of Lord Justice Salmon, as he was, at page MS 340. And if I might just ask your Lordships to look at the excerpt, particularly reading from between letter B and C. There's a paragraph that begins, except in cases. Do your Lordships have that? Except in cases in which murder is reduced to manslaughter on the ground of provocation or diminished responsibility, manslaughter is necessarily an accidental killing. Otherwise, it would be murder. The injury leading to death by manslaughter may, however, be no accident. Sometimes it may be intentionally caused, for example, where a man punches another and fells him to the ground so that he fractures his skull and dies, or a man intentionally sticks a pin into someone who happens to be a haemophiliac and he bleeds to death. Similarly, in murder, a killing may sometimes, in a sense, be accidental. For example, when a man inflicts serious injuries with intent only to do grievous bodily harm and death ensues. In such a case, the injuries are caused intentionally and not by accident. Only the consequences of the injuries are accidental. Accordingly, in neither of the types of manslaughter or murder postulated would the offender be covered by this policy of insurance, since it applies only to liability for injuries caused by accident. Now, I accept, of course, as I've made clear, that is on an observation made by His Lordship on different facts and on an insuring clause rather than the exemption clause. But the reason why I draw your Lordship's attention to it is because in my submission, it sets out the essential distinction between, on the one hand, an intentional injury and, on the other hand, the unintended consequences of it. And for the purposes of the policy which was before the Court of Appeal, it was, on His Lordship's view, obiter, of course, that it was the injury rather than the consequences which were important. And just as that was so in positing whether the death on those hypothetical facts would have been accidental, in my submission, the same should apply on the facts of this case. It really ties into the previous point that I made, which is that insurers, in terms of clause 14, should not be understood to be providing an indemnity on the chance consequences of an attempt to injure. They should only, in a sense, be providing the indemnity on the specific express wording of extension 3, if applicable, but in circumstances of clause 14, it is the intent to injure which causes the exemption to take effect, not the consequences of it. Passing on, my lords, to a case from Australia, decision of the Supreme Court of South Australia, case of Clayton and Mutual Community General Insurance. And your lordships will find that commencing at, if your lordships bear with me one moment.
It's 279.
279, thank you, my lord. It is a case, and I draw your lordship's attention to it particularly because the respondent cites it as supporting the respondent's argument regarding clause 14. My submission about this case, my lords, is that it requires to be seen in the very particular factual context in which the court came to be considering the clause in question. And once that is appreciated in my submission, it becomes apparent that the decision of the Supreme Court of South Australia does not determine the same issue that's before this court, but if anything, rather begs the question. The background is, of course, your lordships will have seen, as a very unfortunate case in which a woman claimed under her house insurance for damage to her house caused when her husband committed suicide by igniting petrol fumes in his car, which was parked in a carport which formed part of the house. The car was, of course, damaged, so was the carport, and from there the fire spread into the house itself through the air conditioning. And could I ask your lordships to draw attention to paragraphs 3 and 4 to begin with, which is at page 280, MS 280. And at paragraph 3, one sees reference to a factual finding that was made at the trial. The deceased left a copy of his will and a suicide note in the house. He removed his son's sailboard from the carport area into the house. It is obvious that he did not intend to cause damage to the house, and the learned trial judge so found. And I'll come back to emphasize that, because that was essential factual finding. There was no intention to cause damage to the house. And then one sees the wording of the exemption clause in question at paragraph 4, and that is that the policy did not cover, quote, loss or damage caused by the deliberate or intentional acts committed by you. There is a second policy exemption there relating to unlawful acts, but it's the first of those two with which we're really concerned there, deliberate or intentional acts committed by you. And at paragraph 6, Chief Justice King made reference there to the basic principle of insurance. He says the principle which is reflected in the exclusion of deliberate or intentional acts in this policy is stated in Beresford and Royal Insurance Company, to which, of course, I've already referred your lordships. And then between paragraph 6 and 11, he carried out a review of some of those authorities. And if I might then just pick up at paragraph 12, because that's when he then comes to consider the application and how the clause was to be interpreted on the facts of this case. And at paragraph 12, he's really referring there to the argument that was advanced on behalf of the insurers. And he states there, the learned judge construed the, quote, act in the phrase deliberate and intentional acts as applying to the igniting of the petrol fumes disengaged from its consequences. The only question for him was whether the igniting of the fumes caused the damage to the insured premises. Such a narrow construction would have consequences which, in my opinion, would frustrate to a substantial degree the effectiveness of the legitimate cover which the party should be taken to have intended. Damage caused by the escape of a hearth fire deliberately lit in the course of ordinary domestic use would not be covered. Neither would damage from a fire accidentally resulting from a deliberately lit candle or damage to the premises as a result of a deliberately driven car accidentally colliding with a building. The party should not be taken to have intended that unintended consequences of ordinary and proper use of the insured premises or ordinary and proper activities carried out in them would be excluded from the cover provided by the policy. Now, I pause there, my lords, just simply to note that the argument which is being considered and dismissed by the Chief Justice there is not the same argument which is being advanced on behalf of the appellant here. It was in effect an argument to say that deliberate simply meant any act which was intended without having regard to the consequences at all. And one could see that that was essentially a very difficult argument for the reasons which are summarised by the Chief Justice. And it's in that context then of having dismissed that argument that he then comes to his view as to what the policy did mean at paragraph 13, where he states, I consider that the act contemplated by the phrase deliberate and intentional act is the act of causing the damage. There must be a deliberate or intentional causing of the damage to the insured's premises. Now, I'll come back to make an observation on that. Essentially, my point is that I take no issue with that, subject perhaps to the word the. In other words, the act of causing the damage. In my submission, one ought properly to see it as being the act of causing damage, which is otherwise covered by the policy. It need not be the actual damage which ensues. But one can see in my submission the key to this particular case when one looks then to paragraph 17. I'll come back to the paragraphs which fall in between, but one can see the key to it at paragraph 17. Because at paragraph 17 over the page on MS 284, the Chief Justice states, I do not think on the evidence that the deceased's action in igniting the petrol fumes in the car give rise to an inference that he realised that the carport would be damaged, still less that the fire would enter the house through the air conditioning. I do not think that his action can be regarded as the deliberate or intentional causing of damage to the insured's premises. I do not think that the deliberate and intentional act exclusion applies to exclude the respondent's liability under the policy. Now, when one reads paragraph 17 together with paragraph 3, what one can see is that on the facts of that case, the deceased had no intention of causing any damage to the house. And therefore, in effect, he had no intention of causing any damage which was the subject of the insurance. Because, of course, it was a claim under house insurance, and the finding was that he had neither intended to cause damage to the carport nor to the house itself. And so when one looks at the way in which the Chief Justice has interpreted the exclusion clause at 13, in my submission, one should bear in mind that the court was not wrestling with an equivalent problem to that which the court is considering here. In other words, on the facts here where there was an intention to cause some kind of injury, simply not the type of injury covered by the actual loss which ensued. In my submission, an analogy with the present case would have been if on Clayton, if the deceased in igniting the petrol fumes had positively intended to cause damage to the carport, but had not intended to damage the house. Then, in my submission, if those had been the facts, he would have intended to cause loss covered by the policy, in other words, damage to the carport, which would be the subject of the house insurance, but just not to the extent which ensued as a result of the fire passing through the air conditioning into the house. So in my submission, that would be a parallel with the current case. And if on those facts, in my submission, Lords, the correct conclusion in Clayton would have been that the loss or damage was caused by the deliberate act because the intent was to cause property damage, which was the subject of the insurance cover. But the matter didn't arise on the facts of Clayton because there was simply no intention to cause damage of the type covered by the policy. And that really brings me back to paragraph 13 in the Chief Justice's opinion. And again, I reiterate that. What he says is that the phrase deliberate and intentional act is the act of causing the damage. There must be a deliberate or intentional causing of the damage to the insured's premises. Now, in my submission, it's perfectly understandable that he phrased it in terms of the damage in the context of that case. In my submission, perhaps a better way of phrasing it in the generality and covering this type of case would be to say, is the act of causing damage, or in this case, injury, which is the subject, otherwise the subject of the indemnity under the policy. So for these reasons, my lord, I submit that Clayton does not positively support the respondent's case, and if anything, it's probably neutral simply because it wasn't wrestling with the same problem. Before I pass from it, if I might draw to your lordship's attention that the discussion that arises in 14 to 16, particularly at paragraphs 15 and 16, because here we have a discussion which, in my submission, bears upon the appellant's fallback argument, the fallback argument being that in terms of clause 14, an act will be deliberate if it is reckless. And make clear that in dealing with this discussion, the South Australia court doesn't adopt recklessness as the test, but nevertheless, the discussion is perhaps informative to some extent. And just reading from paragraph 15 then, what the Chief Justice says is, although intention and recklessness are distinct states of mind, and the latter is not within the policy exclusion, there is a point at which the risk of damage to the insured premises, as it exists, and as it is realised by the insured to exist in consequence of the insured's actions, is so high that the insured's state of mind, notwithstanding that the damage was not designed or planned by him, is indistinguishable from intention. It is difficult to formulate a satisfactory test for determining when unplanned and undesigned damage is to be regarded as intentional. In the American cases cited above, the test adopted is that the insured believes that the damage is, quote, substantially certain to result from his actions, and McGilvray refers to embarking upon a course of conduct in which there was a clear risk of the loss occurring. I do not think that the adoption of a precise formula would be useful. It must be a question for the tribunal of fact whether the risk, as realised by the insured, of the unplanned and undesigned damage was so high that his state of mind should be equated with intention, because it amounted to imposing on the insurer a risk which it could not reasonably be thought to have intended to assume. Now, The court is obviously not in that case wrestling with recklessness as a potential test, but what it is recognising in my submission is that in certain circumstances, even if the insurer's state of mind was not such that the damage was or the injury was designed or planned, there must come a point at which the risk of damage or injury is so high that his state of mind becomes indistinguishable from intention, indistinguishable from being deliberate. And in my submission, looked at in that sense, there is considerable force in the reasoning of Chief Justice King. There must come a point at which, even if the insurer did not intend the actual outcome, the risk of that outcome is so high that his or her state of mind becomes indistinguishable from intention, so that the insurer cannot have been expected to provide cover for that. And the clause in question should be so interpreted. Where I respectfully part company from Chief Justice King is to say that in my submission, it would be useful to adopt a precise formula, and in my submission, that precise formula ought to be recklessness. And my lord, read.
I wouldn't be a very good poker player.
Well, is there a...
In my mind, what I was thinking was that the policy doesn't even say intentional, it uses the word deliberate. And deliberate seems to me to be some distance away from reckless.
Well, the point is the same. I mean, the point is essentially the one that's made by Chief Justice King, my lord. I've used the word intentional, but used intentional as a paraphrasing for deliberate. Deliberate involves some kind of intention to carry out the injury. And the simple point is that if the outcome is, if one is reckless as to the outcome, and there is a degree to which one is indifferent, one knows of or is indifferent to the outcome, then that comes to a point where it becomes, as Chief Justice puts, indistinguishable between intention and the state of mind which the actor actually had. And as I'll come on to submit, the reason why I choose recklessness rather than, I mean, one can see that in the American context, as the Chief Justice states, in the American context, the way in which the problem is approached is by saying that the test adopted is that the insured must believe that the damage is substantially certain to result. And that would be a different way of approaching it, or embarking upon a course of conduct in which there was a clear risk of the loss occurring. And my submission is that once one embarks down that route of recognizing that there may be circumstances in which the risk is so clear, or where the actor is indifferent to the risk, then it is so close to intention that one wouldn't expect and wouldn't interpret the clause as requiring the insurer to indemnify. And the reasons why recklessness is chosen on behalf of the appellant here is because I respectfully submit that it is a test which has something of a pedigree in analogous situations within England, and therefore that is why recklessness is chosen. And with that, and appreciating my lord's immediate scepticism, if I might put it that way, to the analogy between deliberate and recklessness, if I might just draw your lordship's attention to the cases which in my submission would support that test. Lord Hamlin.
What is your definition of recklessness for this purpose?
I'm coming on to that by reference to the authorities, my lord. But if I were to put it this way, if your lordship bears with me a moment, reckless would mean, let me, if your lordship just let me find the precise note so that I don't, it would be a knowledge that there is a risk, or not caring whether the act is risky or not.
What risk are we talking about?
In this case, my lord, for my purposes, it would have to be the risk of death. I acknowledge that. Otherwise, the argument adds nothing. to that which I've advanced in relation to the deliberate act.
So it's a risk of the specific consequence which ensues.
If I am wrong about, in other words, yes, if I am wrong about my primary position is that there need not be knowledge of or there need not be an intention to bring about the specific consequences. If I am wrong about that, then it is sufficient that there is recklessness, in other words, indifference as to those specific consequences.
That's a somewhat lower test, I think, than the test that the Australian judge was describing in the passages you've just taken us to.
I entirely accept that, my lord. I mean, I recognise that if one takes this general problem, this general issue, as to at what stage does the Insurance Act become equivalent to deliberate, then there would be different ways in different jurisdictions of dealing with the same problem. And the Australian judge is recognising in America substantially certain to result, or upon a course of conduct which there is a clear risk of the loss occurring. There may be less difference between that and recklessness, but recklessness, in my submission, is a test that ought to be applied.
Yeah, so just to illustrate it, for example, if you lived in a flat above a Glasgow street and you chucked a bottle out the window and you happened to hit a pedestrian walking on the pavement below, then the American test wouldn't be satisfied. It wouldn't be substantially certain that you would hit someone unless you were doing it on a very busy street. But a criminal test of recklessness of the kind that you've suggested would be satisfied.
Yes. And in my submission, that ought to be sufficient to equate, it ought to be sufficient in this kind of context to equate recklessness with deliberate, because in those circumstances, looking objectively to the insurances that is provided, would one expect that the insurer is providing cover for injury which ensues when somebody chooses to throw a bottle out of a Glasgow flat, where it may not be substantially certain, but at very least it is indifferent as to whether or not the injury ensues. My submission, that is sufficient to bring the equate recklessness with deliberate. And if I may draw your lordship's attention to some cases which, in my submission, support the interpretation of the term. Sorry, my Lord Legate.
Just so I'm clear, from your answer to Lord Hamblin, do I understand that you're saying that if you're wrong in your primary submission, you introduce this recklessness argument, but you're not arguing that recklessness as to causing injury is sufficient to bring you within the exclusion on your primary case?
Would you, Lord, would you like to reflect on that for a moment? Because I think, might I take your lordship, in my submission, no, it would, in my submission, if one has injury and given the connection between the insuring clause and clause 14, in my submission, in principle, there is no reason why recklessness as to the cause of, as to the injury itself would not be sufficient to engage the clause.
So recklessness as to causing any injury is sufficient?
Yes. On the facts of this case, if I'm wrong about that and what were required was recklessness as to causing the specific consequences, then in my submission on the facts of this case, that test would be met in any event. So the higher of the two tests would be met. But in my submission, consistent with the wording of the clause 14 combined with the insuring clause, recklessness as to injury would be sufficient.
Thank you.
Lord Briggs.
And it seems to me in the context of a door steward, a policy about door stewards, the causing of some injury, for example, in the discharge of their function, would set the, if an acceptance of that risk, not caring whether that risk might ensue, is sufficient to trigger the exclusion. And you don't have any kind of de minimis level below which the acceptance of some injury would not trigger the exclusion. You appear to be setting the exclusion very deep into the primary cover.
I acknowledge that, my lord. That must be true. And if I'm wrong about that, then the way of the court controlling that would be to say, well, okay, it requires the recklessness as to the specific consequences which flow. I argue both in tandem, my lord, and if I'm wrong about the first, I argue the alternative, that it need be the specific consequences. And that would, I recognise, have a lesser effect of the type, I think, which my Lord Briggs recognises.
Which you're not contending for any intermediate ground, namely recklessness or intention as to serious injury, rather than any injury or the actual outcome. I mean, you appear to make submissions, as it were, at both ends of quite a large spectrum, but you don't make one in the middle.
Well, I appreciate that, my lord. I mean, the difficulty that arises, of course, on a matter of fact, is it becomes very difficult on the middle ground to determine where one effectively draws the line.
Yes.
And in a sense, that's the reverse of what I say. The part of the difficulty is with the respondent's position on my primary argument, because the respondent argues that there must be an intention to cause serious injury. At least serious injury. If it's not the actual consequences which ensue, there must at least be an intention to cause serious injury in order for it to be a deliberate act. In a sense, the difficulty with that, my primary position being that it is enough that there's an intention to cause injury, that it is difficult to draw the line as to where the intention lay as to serious injury. I mean, in a sense, if there's a punch in the face, is that serious injury? How far much further does one have to go in the circumstance where there's a fall backwards and brain damage ensues? I mean, it's very, very difficult in that context. And so I suppose I have to accept, if I point out that difficulty in relation to my primary argument, then it's very difficult to not live with the consequences of that on the flip side of it when one comes to recklessness.
Yeah.
And so, if I might turn that round, my lord, to rather than accepting that as a difficulty with my secondary argument, pointing it out as a difficulty with the respondent's primary argument, if I may. Now, the authority which I was going to draw your lordship's attention to is the case in re City Equitable Fire Insurance Company Limited. It starts at tab 9 MS 381. I think I only require to take your lordships to one particular passage from it. I draw the court's attention to it because, albeit I accept, of course, against very different background facts to the present case, it involved a consideration by the court of the meaning of willful neglect or default. In other words, precisely the same phrase as features in clause 14 in describing the excluded omissions. And the conclusion of the court, both at first instance and on appeal, was that that phrase, willful neglect or default, was apt to include recklessness. And in my submission, the same conclusion should be drawn as to the meaning of willful neglect or default in clause 14. In other words, it's apt to exclude omissions which are reckless. And your lordships will recall at the outset of my submissions very early on, I had made the submission that willful should be regarded as synonymous with deliberate. In other words, a willful neglect or default, the use of willful is synonymous with deliberate in deliberate acts. And therefore, on my submission, the same conclusion should follow in relation to deliberate acts. If the act is reckless as to whether injury will ensue, then the exclusion is engaged. The background of this case, of course, is quite different, my lords. It was an action for misfeasance against directors of a company where that company had suffered significant losses due to the fraud of one director. His fellow directors had admittedly acted honestly, but were sued for misfeasance, and the Articles of Association provided that directors would be liable for the acts and omissions of colleagues only where they themselves had committed a willful neglect or default. Their omission had been in willful neglect or default. And Mr. Justice Romer, as he then was, gave his view on the meaning of the term willful neglect or default at page MS 408. And reading from the first full paragraph at the top of 408, states, if I may say so with respect, the difficulty is not so much in ascertaining the meaning of the adjective willful as in ascertaining precisely what is the noun to which the adjective is to be applied. An act or an omission to act is willful where the person of whom we are speaking knows what he is doing and intends to do what he is doing. But if that act or omission amounts to a breach of duty and therefore to negligence, is the person guilty of willful negligence? In my opinion, that question must be answered in the negative unless he knows that he is committing and intends to commit a breach of his duty, or is recklessly careless in the sense of not caring whether his act or omission is or is not a breach of duty. So in my submission, Mr. Justice Roma there is expressly including within that very same phrase the concept of negligence. And of course, in that case, the words willful neglect or default are being used to qualify the omissions of the directors, and therefore the court was looking to the state of mind, the director's state of mind. But equally in my submission, clause 14, the same words are used to qualify the admissions of those for whom the insured is responsible, including the employee. And therefore one is looking to the employee's state of mind, and there is no reason why the same approach to the phrase should not be adopted. So just as the director would lose the protection of the Articles of Association if he were recklessly careless, so the insured here loses the indemnity if the employee is reckless as to the consequences of his act or omission. But shortly, if there is recklessness, it would not be expected in terms of this clause that the insurer would provide cover. And for the avoidance of doubt, the same approach was adopted by the Court of Appeal in that case. If I may just provide your lordships with the references to that. Firstly, the Master of the Rolls, Lord Pollock, at page MS 490. Lord Justice Warrington at MS 494, and Lord Justice Sargent at MS 501. 501. And the Court of Appeal then took the same approach in encompassing recklessness within the term. And I might also note, my lords, that the same interpretation of willful neglect or default has been adopted in two later cases, albeit in a contractual context. I don't think I need ask the court to turn them up, but if I might just give your lordships the references to them. The first is the case of Kenyon, Son and Craven Limited and Baxter Horan Company Limited. That's the decision of Mr. Justice Donaldson, as he then was. The particular reference is to be found at MS 645. 645. And the second case was the decision of the then Mr. Justice Bingham in the case of Swiss Bank Corporation and Brinks Mat Limited. And your lordships will find the particular reference at MS 817. Now, I'm not going to ask your lordships to turn them up because the reasoning in both of those decisions is very short. Essentially, the court in each of those two cases adopted the same approach to exactly the same term as was adopted in the In Re City Equitable Fire Insurance Company, and therefore in the contractual context adopted recklessness within it. But the point I make about that, my lord Leggett.
I'm not sure why you say that willful and deliberate have to be symmetrical. It's a different sort of situation, isn't it? We could well accept that a reckless breach of duty to protect somebody might be excluded, but might require a deliberate injury, intentional injury. Without recklessness wouldn't be enough. I mean, they don't have to mean the same.
Well, they don't have to. I accept that, my lord. But if I come back to my primary argument in my submission, the two words should be regarded as synonymous.
But why?
One is looking at.
They're different words, so I mean, why?
They're different words, of course, my lord, but one looks to the purpose of them as being the purpose of the exclusion is the same. One is excluding acts on the one hand and omissions on the other. And in my submission, it would be somewhat odd if a different approach were adopted to act on the one hand and omission on the other. The essential thrust of it is to provide an exemption in both of respective acts and omissions. The explanation I think I gave your lordship earlier, the suggestion I made, is that it's simply the fact it may simply be the fact that in ordinary usage, in ordinary language, it may be that deliberate is more apt to, or more normally used to describe a positive act, whereas willful may more naturally describe a conscious decision. I mean, in ordinary language, for example, if I were to describe, I hesitate to do so, but to describe the behavior of my teenage daughter, if I were to, I might be more inclined to say that she deliberately provokes her younger siblings, but equally I might be more inclined to say that she willfully stayed out after I told her to come home. It respectfully seems to me that it's a natural use of the language is to use deliberate to describe a positive act rather than willful to involve an omission. But there is no, the point being, my lord, is that in terms of coming back to the primary argument that I make, it is difficult to see why one would adopt, when one looks at the purpose of the exemption clause, to exempt that which would otherwise be provided in terms of the indemnity otherwise provided in terms of the insuring clause. It would be difficult to see why there would be a different approach adopted to act or omission.
But can you give us an example of an omission which would give rise to liability or wouldn't, according to your interpretation?
I'm sorry, I missed the first part of that, my lord.
Can you give us an example of an omission which would be excluded or covered according to this interpretation?
On the primary position, my lord, an omission of a door steward, one might have let me leave aside whether liability would be ultimately, there may be other factors that would come into play in the argument, but for example, an omission if a customer were to be inebriated to an extent where they're being thrown out, but it ought to be obvious that they required emergency services rather than being let loose on their own. And let's say the door steward lets them go and omits to call emergency services. That would be an omission, my lord, in my submission. And one would look at that and say, was that a willful omission?
But according to this test, it's whether it's the breach of duty that has to be deliberate or reckless.
Yes.
Not the factual position.
Well, I accept that. Bound to be informed by what the facts are, my respectful submission, and therefore, on the ordinary event, positing that as an example, one would not ordinarily expect that to be willful. One would expect that ordinarily, if they just let them go without thinking about it, that may be negligent, but on the face of it, it would be unlikely to be willful. If one takes the recklessness test and then tests it according to that, what if, for example, there is a degree of personal animus, and one door steward says to the other, no good is going to come of them, but I'm letting them go anyway. I don't care what happens to them, or something of that nature. One might arguably shade into the objective recklessness test.
All right, thank you.
So I think I got to the point of suggesting that certainly willful neglect or default has something of a pedigree that ought to be read across to deliberate act. And one sees a similar approach to recklessness in my submission more recently in the Court of Appeal decision in CP, a child, and the Royal Mutual Insurance Society Limited, which is to be found at tab 4, page 285, NS 285. And again, it is important in my submission to bear in mind the background facts to this case, because it concerned a boy who had, together with friends, set fire to paper in a den which he had built within part of a derelict part of a mill. So what he had set fire to was paper and wooden pallets. It was within a derelict part of the mill, and that fire spread to a part of the mill which was in fact used, with the result that there was significant property damage caused. There was no suggestion that the boy had intended to damage the property in terms of the mill. And of course, the boy's mother was insured for accidental property damage, but subject to an exclusion in respect of any willful, malicious, or criminal acts. Willful, malicious, or criminal acts. And a large part of the judgment in the Court of Appeal was given by Lord Justice Tuckey. A large part of that judgment was taken up with the insurer's argument that willful should be interpreted as simply meaning deliberate in the act of, in the sense of the act of setting fire to the den was intended. In other words, it was a deliberate act, in other words, divorced from any of the consequences. Essentially, the argument that was advanced for the insurers there was equivalent to the argument which was advanced for the insurers in the Clayton case. And in my submission, it was no more likely to win in the CP case than it was likely to win before the Supreme Court of South Australia, when one divorced it from the consequences altogether. But the court went on, in the Court of Appeal, went on to consider the question of recklessness, and in particular, your lordships will see MS 289. One sees in particular the conclusion at paragraph 16. Obviously, if the act is deliberate and intended to cause damage of the kind in question, it will be within the exclusion. Now, I pause to just observe that that sentence in and of itself, one should read that in the context that the court was not there considering facts equivalent to the facts before your lordships. In other words, there was no question in that case of the boy having intended to cause property damage at all. And therefore, I don't think the Court of Appeal should be the term intended to cause damage of the kind in question. I recognise if one were to read that, that might be said to go against my primary argument, but the court was not considering the precise terms of the precise facts of the type which we're concerned with here. The Court of Appeal went on to say then, it will be willful as the judge held and might also be malicious or criminal, but for an act to be willful, I do not think it is necessary to go as far as this. It will be enough to show that the insured was reckless as to the consequences of his act. Recklessness has been variously defined, but if someone does something knowing that it is risky, or not caring whether it is risky or not, he is acting recklessly. Put more precisely for the present purposes, if the insured is aware that what he is about to do risks damage of the kind which gives rise to the claim, or does not care whether there is such a risk or not, he will act recklessly if he goes ahead and does it. I think such conduct was intended to be included in the exclusion, and I would equate a reckless act with a willful act for this purpose. This approach focuses on the state of the insured's mind when he does the act rather than its intended consequences. Defined in this way, the exclusion does not require the insured to intend to cause damage of the kind in question. And at paragraph 17, Lord Justice Tuckey goes on to say that equating willfulness with recklessness is consistent with the dictionary definition of willful, which includes obstinate and headstrong conduct. And in my submission, that is essentially the approach which the court ought equally to adopt in relation to the present case. In essence, one reading the exclusion clause would not expect insurers to cover conduct which is reckless as to whether injury will ensue. It is another example of the same approach being adopted as was adopted in the In Re City equitable case, which I've referred to in the cases which followed upon that. The essential point is this: if conduct meets the test of recklessness, then for the purposes of insurance cover, that should be equated with deliberate or willful acts or omissions. Because properly construing the contract, one would not expect the insurance to meet injury or damage caused recklessly. And I suppose it comes back to my Lord Reed's point regarding the example of the bottle thrown out of the window. Would one construing an exemption clause in equivalent terms to property damage expect an insurer to cover injury caused in those ways which are reckless, in a sense, indifferent? In my submission, no. Now, in my submission, I commend the test which is expressed at paragraph 16. In other words, recklessness has been variously defined, but if someone does something knowing that it is risky or not caring whether it is risky or not, effectively the latter part, I think this picks up on the question asked by my Lord Hamblin earlier. So knowing that it is risky or not caring, the latter part in effect amounting to indifference. And in my submission, that is the test that your lordships should adopt. as I understand it, I think the respondents, if they adopt a position which they say that if recklessness does form part of the construction of the word, then they suggest that there must be actual knowledge, actual recognition of the risk, as opposed to constructive or indifference as to the test. And to that end, they have cited, I think, the judgment of Lord Justice Diplock, as he was in the case of Fraser and B.N. Furman Productions Limited, which is at tab 6, page 3, starts at page 303.
Can I just mention, Mr. Beatty,
Yes.
I'm certainly not discouraging you from taking us to any authorities that you want to, but I do bear in mind that your time will expire at 1 o'clock.
Yes.
At some stage, you're going to have to tell us why, on the facts of this case, it matters whether or not there was whether or not the clause in the policy covers intent to injure on the one hand, or
Yes. Well, let me address that. If the case of Fraser is perhaps less important, and no doubt Mr. Milligan may refer to it, and if need be, I can always come back on it later. I mean, the point I make in passing simply about that case, my lords, is that it was a very particular circumstances of that case. But I can come back to that in due course. And equally, my lords, I may say this: I don't intend to take up any time by directing lordships to the differing authorities which bear upon the case, the interpretation of arising out of, and whether that contemplates a proximate cause or a more remote cause, because in my submission, as I'm coming on to, the test, even if it's a proximate cause, the test is met in the present circumstances. So if I might then turn to the application of the policy to the facts of this case, and in my submission, I can state them relatively shortly. I rely upon the door steward, who was, of course, the first offender in this action, having carried out an assault on the deceased. Your lordships will have seen that the conviction was that he committed an assault by seizing the deceased on the neck, forcing him to the ground, placing him in a neck or chokehold, compressing his neck, and restricting his breathing. And that's agreed in the statement of facts and issues of paragraph 7, MS 31. Your lordships will also have seen it, I think, in the statement of the sentencing judge, which starts at MS 176. In my submission, that was an assault. It was a deliberate act. It was intended to cause injury.
Now, why do you say that?
It was a compression of the neck. It was placing in the chokehold, compressing his neck, and restricting his breathing. That in and of itself, my lord, in my submission amounts to an intent to cause injury, albeit relatively minor injury compared with the consequences that flowed from it. In other words, my lord, put simply, if one is to carry out a neck or chokehold of that nature and to apply that degree of pressure, injury is, to a greater or lesser extent, is an inevitable consequence of that. It's in my submission.
Well, you say that. The judge, the Lord Ordinary, rejected rejected recklessness, let alone intention.
Rejected
recklessness, which would be a lesser test than intention.
Yes, and Lord Ordinary rejected recklessness on the basis of carrying out a comparison of the test of recklessness according to Scots criminal law, was the approach that he took. And therefore, in my submission, my lords, not the test that ought to be applied in the present case. The assault in and of itself caused damage. It was a deliberate act. There is no doubt that it was intended. The act in and of itself was intended. And to carry out an act in that way which restricts breathing, in my submission, carries with it an intention to cause an injury. The injury is inevitable. And the liability for the death owed by the employer is, in my submission, a liability arising out of that deliberate act. Because
if you look at the Lord Ordinary case, if you go to MS 190, paragraph 14 of his judgment, you'll see that he cites the case of Patrick, or CP, and Roll London Neutral, and he quotes the section of Lord Justice Tuckey's judgment that you took us to. Then at the end of it says, in the present case, and you referred us to the test in paragraph 16, in the present case, there was no evidence of the type of intention envisaged in paragraph 16. On the contrary, the trial judge's sentencing statement confirmed that the first offender's conduct was badly executed rather than badly motivated. So he specifically rejects the application in this case of the test in paragraph 16 of CP, and he returns to the subject of paragraph 21, where he says that this is on page 194, where he says the death of the deceased was caused by the negligence of the first offender. His actions were not willful or deliberate in terms of the policy, as he did not intend to kill the deceased, and there was no evidence that he was reckless. So what do you understand?
Well, starting proposition I make is, my lord, that this is the Lord Ordinary, of course, heard a proof, but it was a proof on an agreed set of facts, and therefore the Lord Ordinary is not in a situation where he reached those conclusions having had the benefit. There's nothing in those findings which turn on the benefit of having seen and heard the particular witnesses. He has reached a conclusion on the agreed set of facts. In effect, what he's.
And did you appeal against his finding that there was no recklessness in terms of paragraph 16 of CP?
Yes, my lord. There was an argument before the Inner House in which I submitted that. Of course, I didn't appear before the Lord Ordinary. I shortly before the Inner House. But they were
part of your grounds of appeal to us.
I think the second issue, my lord, from recollection, is whether or not it was reckless. I mean, the short point that I make, my lord, is that, let me just check that, Mr. Cleland will check, but the short point that I make is that this court is just as capable of reaching a conclusion as to whether there was recklessness, as was the Inner House or as was the Lord Ordinary, given that each of the courts looking at it is dealing with it simply on an agreed set of facts.
But the trouble is, the agreed set of facts in the joint minute don't cover this point. Well, it's not an agreed set of facts at all, but the joint minute doesn't actually contain any agreement as to whether or not there was recklessness or intention to injure, does it?
No, other than the acceptance, of course, that there was no intention to kill. That's accepted. Yeah. But the recklessness point, what is agreed in my submission, and the key facts from which the inference of recklessness can be drawn, and is the same submission that I made before the Inner House. And your lordships will see that the Inner House did reconsider recklessness, but the three judges of the Inner House came to they didn't reach a definite conclusion, and for slightly different reasons, they dealt with the question of recklessness. But the facts upon which the inference of recklessness can be drawn are agreed facts. And in particular, in that regard, I place emphasis on the fact that it is an agreed fact that the training of the doorman was that he had been trained that the neck hold was to be applied, it was not taught as an acceptable method of restraint, and was considered so dangerous that it was not demonstrated in a classroom setting. So he ignored his training, and in so doing, it is also an agreed fact that he leaned on the deceased with all of his weight and put as much pressure on his windpipe as possible for a period of up to 3 minutes until the police arrived. Now, if one is looking at the question of recklessness, and again coming back, drawing the analogy with the bottle thrown out of the window, in my submission, even without the question of training, it may be considered that to place pressure on another person's windpipe in that way, with as much pressure as possible for an extended period, would give rise to an obvious risk of asphyxia. All the more so if your job is one of door steward, in circumstances where you have been given training and you have been taught that that is not an acceptable method of restraint. So one is not just applying an obvious, it's not just an obvious risk to anyone, it's a particularly obvious risk to someone who has undergone that training and yet has ignored it. Those are all agreed facts. Lord Leggett.
It's not really appropriate, though, is it, to ask the court on a highest level of appeal to make a finding about somebody's state of mind?
Well, I would entirely recognise that it is not normally the kind of question with which one would come to the highest court. But nevertheless, it is a question on which this court is just as capable of reaching a conclusion as the lower courts have been capable of doing. And therefore, to some extent, I ask the court's indulgence in looking at that question again, but it's a question that's there just as much for this court as it would be for the lower ones.
It's your burden of proof, is it, on the exclusion?
It is, my lord.
Yeah, thank you.
Lord Burrows.
Just to be clear, I mean, in one sense, all we've got to go on is the assault conviction. Now, is it your submission that one is required to prove an intention to injure in order to get a conviction for assault? I mean, is that part of your submission?
No, well, might I say this before I answer that question directly, my lord? In my submission, that is not all that the court has to go on. It's not all that the courts below had to go on, because one had an agreed statement of facts, and that particularly encompassed much of what was said in the sentencing judge's statement, which reflected it was agreed the accurate circumstances surrounding. So one has all of the background facts regarding training, lack of training. One has the particular circumstances as to the actual application of the force in question. So one has the fact from that he was seen to apply as much pressure as he could to the deceased's windpipe as was possible, whilst placing his leg out and restraining it. So I respectfully don't accept that we simply have the fact of conviction. That is not all. One looks to all of the surrounding facts, and therefore my answer to your lordship's question is no. I don't simply rely upon the assault in and of itself as giving rise to definitely an intention to injure. That wouldn't necessarily arise on every case of assault as a necessary component of assault. One can think of examples of brandishing a gun or so on and so forth, but there's no actual intention to cause physical injury. But in my submission,
the crucial point is, leaving aside, we're not in the realm of what you might call assault by putting fear into people. We're talking about something different than that, which might well be classed technically as a battery. But the definition, as I understand it, of battery is the application of force.
yeah.
Now, there's no doubt that the conviction here tells us that there has been intentionally applied force. That would be
Yes.
difficult to dispute.
Yes.
But what you're asking us to do is to go one step further and say it's the intentional application of force plus the intentional application plus the intention to injure. And that's where I'm at the moment just asking you where you're getting that from. And I think the answer coming back is, you say it's just a common sense inference from the surrounding facts.
And it is the same inference which, if I'm wrong about that and your lordships are not with me on that, it's the same surrounding facts which give rise to the inference of recklessness.
Curious, for those of us who have some experience of Scottish criminal procedure, an indictment like this, on an indictment of this kind, you would expect the jury to have a number of options: convicting of murder, or if there was no intent to kill or recklessness as to death, convicting of culpable homicide. And below that, if they didn't accept that death had been caused, they could convict of assault to severe injury or assault to injury. They didn't even convict of assault to injury. It's simply assault, which is usually dealt with as a matter of summary complaint. One would imagine if the indictment was in the form that they used to be in, they would have had to actually delete the words to injury in order to convict of simple assault.
Yes, and
it's not as if one can just look at the conviction and infer that the jury must have thought there was an intent to injure here.
no, I take your lordship's point. I mean, part of the curiosity of the way in which it seems to be have transpired at trial may relate to the findings on post-mortem and the findings of the pathologist in relation to the intake of drugs, which even on the pathologist report admittedly gave to the possibility of an effect on the deceased's heart, even if he'd had some degree of force applied to him and so on. And that may be the clue to how the jury viewed this as it ultimately came to be. I take the point that my Lord Reid makes. One doesn't have that assault to injury.
Yeah.
I don't think I think I'll be repeating.
I should also just mention that to think in terms of the English distinction between assault and battery isn't helpful here, because there's no such distinction in Scots law.
No, well, I have to confess that's a distinction that is something of a mystery to me, the difference between assault and battery. But the point I make is, I regret I'll be repeating myself if I go on too long, but on this point. But the application of force in the way in which it is agreed in the statement of facts and issues, and the way in which it is expressed by the sentencing judge, where there is a deliberate application of as much force as possible on the windpipe, in my submission, is sufficient to give rise to the conclusion that there was an intention to injure. If I am wrong about that, that in combination with effectively the ignoring of training, in my submission, the test of recklessness is met. To ignore training in applying force for 3 minutes to someone's windpipe, in my submission, plainly meets the test of, as I would put it effectively, indifference as to whether injury would result. And even, I make it plain, if recklessness as to injury per se is not sufficient, then those facts in my submission give rise to an inference as to recklessness as to death, because one's leaning on someone's windpipe. So, for all of those reasons, my lords, in my submission, clause 14 applies on the facts of this case, and therefore the exemption takes effect. Extension 3 may be of less importance, but lest there be any doubt, in my submission, this was a liability arising from or out of the definition of wrongful arrest. The unlawful physical restraint, in my submission, was in and of itself within the definition of unlawful, within the definition of wrongful arrest, and subpoint 1 under the definition of wrongful arrest, the act carried out in the course of the arrest, in my submission, would also fall within that definition. From the agreed facts, your lordships will have seen that it was agreed that the deceased was being restrained pending the arrival of the police, who had been telephoned, and they'll find that in paragraph 4 of the statement, facts and issues. It's 12:58, my lords. For all of those reasons, in my submission, the exemption clause applies, and for that reason, the appeal should, in my submission, be allowed, unless there is anything I can assist your lordships with in the 2 minutes that remain before lunch.
It seems not, but what we might do is adjourn just now, just in case you have any anything you want to add at 2 o'clock. So we'll adjourn just now and resume at 2 o'clock, and we'll expect to be turning to Mr. Milligan very shortly, but we won't make you finish your submissions just yet in case there's anything you want to add.
I'm grateful, my lord.
Thank you very much.